Evening, ladies and gentlemen. Thank you for joining us. My name is John Wellborn. I'm a lecturer with the Political Economy Project in the economics program here at Dartmouth. And we are lucky to have a guest speaker for Econ 16 regulation this evening. We are visited by Clark Neily, who is Senior Vice President for Legal Studies at the Cato Institute. His research interest is in constitutional law, overcriminalization, coercive plea bargaining, police accountability, and gun rights. Before joining Cato, he was a senior attorney and litigator at the Institute for Justice and director of Institute Center for Judicial Engagement. He's an adjunct professor at George Mason Antonin Scalia School of Law, and he received his BA in Russian and philosophy from the University of Texas and a degree from the University of Texas in law. Welcome.
Thank you very much.
Appreciate
it. Well, it's great to be here. I was mentioning at dinner with a couple of your fellow students. My best friend from high school, I went to high school outside of Dallas, and my best friend was on the swim team. I was a diver, and he went to Dartmouth here and had really one of the best college experiences of anybody I know. So appreciate you sharing the magic with me. So I have been, for most of my professional life, a constitutional lawyer. For the first 2/3 of my experience, I was a public interest lawyer at the Institute for Justice. Basically, I sued government officials or bureaucrats, if we want to cut to the chase, on cases involving property rights, occupational freedom, some free speech, things like that. And I've written a book about the judiciary's failure to fully enforce constitutional limits on government. And then kind of somewhat late in my professional development, I got really passionate about criminal justice reform. I've sort of thought of myself as a fighter of injustice for most of my professional life and felt somewhat chagrined that when I took a hard look at the criminal justice system, I came to the conclusion that it is far and away the number one purveyor of injustice in our society. I think it's actually badly misnamed. Some people call it the criminal legal system. But at the Cato Institute, which is a libertarian think tank, I basically manage or oversee all of the legal policy work that we do. That includes constitutional law, criminal justice reform. We have a scholar who's very focused on the surveillance state and national security. And we do a fair amount of work in the administrative area as well, which is what we're here to discuss tonight, or at least start off with. I was mentioning to John, I'm always more interested in answering questions, if you have any. I hope you do, because I don't want to guess what's on your mind. I'd just rather respond directly to whatever is on your mind. But I'll start off with at least sort of a quick sort of setup about what's going on in administrative law to sort of hopefully prompt that discussion. But I'm more than happy to talk about any aspect of the Constitution or law that you're interested in. I guess with that, I will sort of dive in and say, as you know, one of the genius designs, or at least I think it's a genius design of our constitutional system, is to divide government power in various ways to try to essentially keep us safe from tyranny by dividing up the total quantum of government power, not just horizontally among 3 different branches, but also vertically among federal, state, local government. I think that was extremely wise. I think it is the nature of government to, I don't know if I guess I'm going to date myself here, but if anybody's seen the sequel to the Terminator, they've got this sort of liquid metal robot that can reform when you blow it up. And I think government's constantly sort of trying to do that, is trying to aggregate power, because that's sort of the natural impulse of government. I don't think there's necessarily anything particularly sinister about that. It's just the way that government acts. When I was a kid, we lived outside of Boston. We had a couple of acres of land with a barn. We tried goats one summer. Don't do that if you don't have to, would be my advice. But one of the things I learned about goats is that if you let a goat inside where the goat food is kept, that goat will keep eating until it's dead, because that's what goats do. So similarly with government, government will exercise every single bit of power that you leave lying around. Or at least that's my perception based on my years in public policy. And so the I'm going to move on. I'm not trying to be pedantic, but it's really important to set the stage. And it's easy to forget this based on what we've seen over the past fill in the blank number of years. But the executive branch is not empowered constitutionally to make policy. That's not the business of the President of the United States. It's not the business of the administrative agencies that largely comprise the executive branch. They are not there to decide what is the optimal policy. That job is constitutionally committed to the legislative branch, to Congress. And so two things are true. First, policy is only legitimately made by the legislative branch because that's the only branch to which that job is constitutionally committed. At the same time, however, you've got a federal government that is so big, it expends $5 or $6 trillion on various programs every year. Nobody can count the number of federal agencies. I've tried, Grok has tried, my other AIs, it's a couple thousand, employs a couple million people. So you've got this sort of huge entity, namely the federal government, and you have to sort of manage it somehow, right? And you could think of the president as sort of the CEO of this big company, but ultimately you're going to need departments that specialize in carrying out whatever function it might be, whether it's keeping the environment healthy or protecting us from foreign enemies, et cetera. And so that's what we call the administrative state. Those are the various agencies that make up the executive branch. And the most important thing, I think, for the purposes of our discussion tonight is to remember that none of those agencies has any constitutionally legitimate authority to make policy. What they have at most is the authority to sort of fill in some gaps when Congress has articulated a particular policy, but maybe they haven't spelled it out with complete detail, which they typically don't. And so the question of Chevron deference, which was recently retired by the Supreme Court or reversed in a case called Loper-Bright from last term, essentially boiled down to the question of when there is some dispute about either the scope or the nature of the authority that an agency has, how do we decide the answer to that question when there's a dispute? So let's take kind of just a step back and talk about what some people refer to as the principal-agent problem. I suspect most of you have not really encountered this in your own lives, but you will at some point, and it simply boils down to this. When you have somebody who's in charge of getting a particular thing done, but they're not going to do it themselves, they bring in somebody else or some other group of people to perform that mission. So the principal is the one who has the responsibility to get the thing done, and then the agents are the ones to whom some amount of power is delegated to get it done. It could be the manager of a McDonald's delegating authority to the next shift to cook the hamburgers and the French fries, et cetera. But I'll give you a more concrete example that I actually just came up in my life. My wife and I have two kids, 11-year-old son, 10-year-old daughter. We homeschool them. We love to travel. And so my daughter, who is obsessed with all animals, but particularly cute, fuzzy ones, has been bugging us for years to go to Australia so she can meet all the marsupials. And we did. So we went for 2 weeks. And we've got a dog and a cat, so I needed somebody to come in and take care of the dog and the cat and basically look after the house. One of our neighbors had a college-age son who was happy to do that. And it sort of dawned on me that, I got to figure out, I've never done this before, so how do I convey to this person, who I didn't know very well but seemed, very nice and responsible, what is the nature of the job that I'm asking you to do, right? Don't let the dog or the cat starve, obviously. But what happens if, for example, one of them has a medical issue? Is this person empowered to call the vet? Are they empowered to, sign my name to a bill from the vet? That kind of thing. And so, I ended up having to write up, basically, here's what we want you to do. The problem with that kind of situation, and that's essentially what Congress does when it comes up with some policy, like we should have an environment that is clean but still allows people to operate internal combustion engines and factories, right? So there's some tension there. it's Congress's job essentially to figure out how you get that balance, right? So you get the benefits of productivity that come from burning fossil fuels, but we all still want to be able to breathe and not get sick, right? Somebody has to figure out how to balance that, and that's the job in our system of Congress. And they do that by writing legislation, by enacting laws. But the challenge that they face is the same one that I face as a homeowner, which is exactly what level of detail do you go into, for example, when you're trying to get this job done. And for example, when I say to this person who's house sitting, hey, help yourself to anything in the refrigerator or the pantry, right? Does that mean like literally anything? What about my liquor cabinet, which sits right on top of the refrigerator? Help yourself to that, right? Or what about, I have this little collection of Madeira. I don't know if you ever heard of it. It was the wine of the American founding. It's a fortified wine like port, but what I love about it is that the more you beat it up, the better it gets, kind of like us. They toasted the Declaration of Independence with it. They launched the USS Constitution with it, so I have a soft spot for it. My wife's really good at getting gifts, and so she's gotten me a bottle of Madeira from 3 really significant dates in American history, including, and I'm just curious, is anybody like an American history scholar at all? 1868, does this ring a bell at all? This is the ratification of the 14th Amendment, arguably the most important amendment to the Constitution, one that I have tremendous affection for. So I actually have a bottle of Madeira from 1868. And when I told this guy who's house sitting, help yourself to anything in the pantry or the refrigerator, I think I would have been quite heartbroken if he had helped himself to my 1868 Madeira, which he didn't. But that is the challenge, is essentially communicating to the agent what is the scope of your authority to carry out whatever mission is being handed off to you. And that's the essential function of Congress. Come up with a mission, say what the policy is going to be, and then hand it off to the executive branch, which basically means handing it off to one or more administrative agencies. These are enormous undertakings that many of these agencies are responsible for. The Food and Drug Administration obviously has a tremendous amount of responsibility and a lot of missions that they have to execute. Everybody's Department of Justice and on down. And I think it is really not realistic to suppose that Congress has the ability to explicate in exquisite detail everything that the agency can do and all the things they can't do in fulfilling whatever mission they've been assigned by Congress. And so, as I alluded to a moment ago, the question then arises, if an agency looks at a statutory grant of authority, looks at a law that Congress passed, and sees in that law an authorization to do their job in a particular way, but it's not explicitly spelled out, how do you decide if somebody then comes along and challenges that and says, hey, EPA, there's nothing, Congress didn't spell out any power for you to tell me that, I can't operate a giant lead smelter, next to a playground. That's just not in there, right? And then you have this dispute between the person who wants to operate the lead smelter and the bureaucrats at the EPA. And the question then arises, how do you resolve that dispute? And in our system of government, disputes generally, though not always, but they generally end up in front of the judicial branch, which is an adversarial system. So the two parties, or sometimes there's more, but let's just keep it simple. Two parties to the dispute come in and argue in the court about why they think they're right. The issue when it comes to this question of Chevron deference is what is the appropriate way for a court to decide a case where an agency has interpreted a law in a way that empowers it in some way, that then the agency uses that interpretation to execute their mission. So the agency has interpreted that law in a way that's reasonable, but it's not the only way that you could have interpreted it. And it may not even be the best way. So if you were starting from scratch as a judge, you might say, well, I actually think that law means this, but the agency has said that it means not this, and that's a reasonable interpretation, just happens not to be the one that I would have come up with if I had been starting from scratch. And so in the Chevron case, which was decided in 1984, what the Supreme Court said is that judges should defer to an agency's interpretation of a statute as long as it's reasonable. Doesn't have to be the best interpretation, it just has to be reasonable. Hopefully you can already see a problem because, and I hope I don't get too meta here, but reasonable people can disagree about what's reasonable. So right off the bat, you've got a bit of a challenge. Was the agency's interpretation of the law reasonable or was it unreasonable, right? And think about what you're saying if you're a judge and you call the interpretation unreasonable. Like you are literally saying the administrator of the EPA was behaving unreasonably. This person doesn't know what they're talking about, and they endorsed an unreasonable interpretation of the law, which is, believe it or not, something that judges are not always super enthusiastic about doing. I'm not an economist, but I have some familiarity. I have a lot of friends who are economists, and I think it's a fascinating discipline and lens through which to assess human behavior. I will tell you that I, having been a public interest lawyer for the better part of 2 decades, absolutely subscribe to public choice economics, which is essentially the idea that instead of taking an idealized version of what motivates government actors, public officials, everybody from legislators to agency bureaucrats to police officers out on the street, that there isn't some magic transformation that happens when you go to work for the government, that suddenly your heart is pure and you wake up every day thinking, how can I make the country the best place that it could be? You're still human, and you're still motivated by the kinds of human incentives that you're all familiar with. So for example, if you run a big agency, do you want that agency to be bigger next year or smaller? Bigger. Do you want it to have more money to spend next year or less money? More money, et cetera. So these are dynamics that public choice economists would say, if we want to have an accurate understanding of why government officials and government entities like administrative agencies do what they do, we should not look at it sort of through a lens of, I don't know, sentimentality. We should just look and see what they're doing. And what you'll find oftentimes is they're making decisions for totally human reasons. I'll just give you an example. I mentioned the FDA before. If you are the head of the FDA, are you going to have that job the rest of your life? No. What employment opportunities might be available to you after you're done being head of the FDA? Anybody ever heard about K Street? What kinds of companies do you find on K Street besides law firms? Lobbying firms, right? Do you think you might want to keep the industry happy during your time as head of the FDA? If you want to have a nice fat salary on K Street, you might be thinking about that, right? And I'm not saying, by the way, and I hope you don't hear me to be saying that every government official and every executive branch administrative agency head is thinking about nothing but their paycheck after they get done with that job. I don't believe that to be true. But neither am I going to pretend like it's not on their mind, at least some of the time. The truth is somewhere in the middle. And so what happened in this Loper-Bright case that the Supreme Court handed down this past term, and one of the things that's great about being a constitutional lawyer, by the way, and I know this is true in other professions. My sister's a OBGYN doctor in Maine, and I have friends who are cops, and many professions have good stories. Constitutional lawyers have some good ones as well, although usually we're telling people stories secondhand. But Loper-Bright has a really fun fact pattern, I think. I don't know how many of you are really up to speed on the North American fishing industry. I wasn't. I'm still not. But if you read the case, you'll know a lot more about it than when you did going in. It turns out we've got all different kinds of fisheries. They fish for salmon up in the Pacific Northwest. They do, swordfish up in the Boston in the Northeast. And apparently there's a herring fishery. I wasn't totally aware of that. I don't really eat a lot of herring. But anyway, it turns out that these different fisheries are subject to a whole complex web of regulations. Some of them overlapping, some of them are discrete and different. And generally speaking, what they all have in common is that they are all subject to inspection by federal fisheries inspectors. That doesn't mean that you're going to have I think they're from NOAA, and that term just went out of my head, might come to me in a second. These inspectors will actually go out on the boats, but they do it on a spot check basis. They're not going out. You don't have one on your boat every time you go out. But when they show up at the dock and say, hey, we're coming out with you, you have to take them. Well, guess what? It turns out that actually cuts into your profits because you got to feed these people. You got to have space for them. That means one more hand that's not working on the boat. You're going to have a less productive outing when you have one of these inspectors on board. And this raises a very fundamental question that may seem only abstractly interesting to us because we don't make our living this way, but it turns out to be extraordinarily important if you do make your living in the whatever fishery. Who's going to pay for that? Who pays for the inspector, and who pays for the fact that you're going to make less money on that trip? And it turns out that Congress has, for reasons that remain sort of obscure, provided detailed information about that with respect to some fisheries, and in other cases it just has said nothing. And so the North Atlantic, or just the Atlantic herring fishery, is one where Congress didn't say one way or the other. So what do you suppose the federal agency in charge of making sure these inspectors go out of the boats, what do you think their position was if Congress is silent on the question of who picks up the tab for inspectors on the herring boats? Anybody? Any future administrators in the room? Yeah, you're going to want the fishing boat operator to pick up the tab, not you. That comes out of your budget, and you'd prefer not to spend that money. So they came up with a regulation that said, Congress has not spoken, so we're going to interpret the statute as authorizing us to stick the private commercial fishing boat operators with the tab for our inspectors. As you won't be surprised to hear, both because of how human beings are, but also because this case ended up in the Supreme Court, the herring boat fishers didn't really like this. And so they sued and said, look, that's not a reasonable interpretation of that statute. Because, among other things, we know that Congress knows how to spell it out as to who picks up the tab, and they were silent here, so that means not us. Obviously, the government disagreed. The lower courts, applying Chevron deference, essentially said the question for us is not what is the best reading of the statute. That's not for us to decide. We might make a different decision. The question for us is whether that was a reasonable interpretation of the statute to stick the fishing boat operators with the expense of our inspectors, and yeah, it's reasonable. That went up to the Supreme Court, and there were actually two different parties that were litigating this up to the Supreme Court. I kind of am bummed that the other party, so it's called Loper Bright, but the other party was called Relentless. I don't know why they were called that, but that was their name, and that would have been such a better name for this case. But anyway, it's Loper Bright. Both of the litigants in the case not only asked the Supreme Court to reverse the lower court holdings that the interpretation of the statute was reasonable, but to in fact jettison that entire analytical framework that we refer to as Chevron deference, and essentially say, look, going forward, courts should have only one question when presented with a dispute between an agency and some other person or entity or business about the meaning of a statute that under which that agency operates. And the only question that a court should have is, what is the correct interpretation of the statute? Does the statute require the private herring fishing boat operators to pick up the tab for these inspectors, or does it not? And that's a really different question, and so hopefully you can see, because again, there will often be these very powerful public choice dynamics that cause agencies to interpret statutes in a way that's quite favorable to them, like making somebody else pick up the tab for your inspectors. And you can get wildly different results. In fact, you will get significantly different results depending on whether the judiciary starts with the premise that the agency got it right, as long as it's reasonable, even if you might have disagreed if you were starting fresh, versus saying, we're not gonna give any deference to the agency's interpretation. So if you think about the law as whatever note I left for the house sitter, that judge is going to come in and say, I don't care what the house sitter thought this meant, I'm going to tell you what it means. So hopefully that's sufficiently clear. It's a pretty big deal. You're going to get significantly different results. One kind of misconception that I do want to clarify that I think is, there are some fair criticisms of the Supreme Court's decision to overturn Chevron deference and just basically say judges will be the ultimate determinants. But one criticism that I think is not fair is that courts are now going to completely disregard agency expertise. I absolutely, even as a libertarian, I absolutely agree with the proposition that agencies tend to have significant expertise about the things that they're in charge of. I myself do not know a great deal about constructing like nuclear reactor facilities, if you can imagine. I'm not really sure what kind of concrete you should use or whether that's even the best substance, and I don't know how thick it should be. And if you made me a judge, I wouldn't suddenly have, like, that knowledge wouldn't somehow get downloaded into my head. But just because the court is not going to defer to the agency's interpretation doesn't mean that they can't listen to it. And of course, as a party to these legal disputes, the agency will have plenty of opportunity to come into court and explain the basis for its interpretation of a given statute. To explain, for example, like, look, if we had to pick up the tab for having an inspector on every boat in every fishery where Congress has not spoken as to who picks up the tab, we'd go broke, or we wouldn't be able to make it work, or whatever, right? They will have that opportunity, and they will, going forward, have that opportunity to share that expertise with the court. They just won't have the ability to sort of impose that on the court as a sort of a set point, a default point. And I will say, as somebody who's been doing public policy for most of my life, it would be hard to overstate how much it matters when you go into court in a legal dispute. If there's sort of a default that somebody is presumptively right, and then one party has to overcome that presumption somehow, it is unbelievable how much work that does in lots of litigation. Just having the presumption that you are right is one of the most powerful things that you can have in litigation. How do I know? Because I've been on both sides of it. If you're a constitutional litigator and it's a First Amendment case, the Supreme Court applies something called strict scrutiny, which is essentially a way of saying, hey, these people who are trying to talk and being told by the government that they can't, they are presumptively right that they get to talk. And the government carries a very heavy burden of showing that whatever speech suppressing regulation they're trying to enforce is valid. Flip that around. If you're representing a property owner, I don't know, is anybody familiar with the Kelo case involving eminent domain? So I was on the trial team for Kelo. There was a case where the question was whether the Fifth Amendment contains a requirement that the government can only take private property involuntarily for a public use. Like you would think that would be like a highway or a school or something. So New London, Connecticut exercised its eminent domain power to bulldoze a working class neighborhood to simply replace it with Yuppieville, with nicer townhomes and a meeting center for Pfizer executives. And then the question was, okay, is that a public use? Because all these properties are going to be private. And in those cases involving, for example, property rights, the court presumes that the government is right, and then you have to overcome that presumption by showing that they are wrong. And that's really hard to do. It's hard to do. So I guess I'll tie up by saying that it's really impossible to predict what the practical effects of the Loper-Bright decision will be in getting rid of this Chevron deference and saying from now on courts will be the ultimate arbiters of the meaning of statutes that empower federal agencies. And I think two things are true that are somewhat in tension here. On the one hand, there's a great deal of kind of inertia. If you've got an enormous bureaucracy like we do, and it's been doing things in a particular way for decades or centuries, really decades. We didn't really have a huge bureaucracy back in the 1800s, but many decades. There is kind of a tendency, just like in physics, for that inertia to exert force and to just continue until met with a sufficient opposing force. And that's a lot. That takes a lot to sort of just change that business as usual. On the other hand, I think it would be impossible to overstate, but perhaps I've already tried, to overstate the significance of essentially handing over, or at least causing administrative agencies to relinquish that presumption that they're right when they interpret a statute. That does a tremendous amount of work. It's hard to document, it's hard to articulate and sort of test or measure empirically, but I can tell you as a constitutional litigator, it does an immense amount of work when the government goes into court and is able to say, hey, presumptively we're right, and it's their job to show that we got this wrong. So I'm not sure how things are going to shake out. I don't think there will be like an enormous sea change where like suddenly the EPA can't enforce any clean air regulations and everything they'd try to do to clean up a toxic waste site or make some river more clean is just going to go off the rails because the mustache twirling villains who are spewing chemicals into the environment have now got this new sort of weapon to deploy. I don't think that's realistic at all. But I do think at the margin that it's going to be more difficult for administrative agencies to essentially implement the vision of whatever administration happens to be in charge at the time. I'll just close with one sort of illustration that I think is enormously important, but about which reasonable people can disagree. And that's whether the electric generation industry in this country should move from fossil fuels to renewables, and if so, when. And this is something that Congress has been debating for years. And as you might imagine, Democrats and Republicans tend to disagree about. And so when you've had Democrat presidents, they've tried to get the power industry to make the shift to renewables. And when you have Republican presidents in office, they tend to, take the foot off the gas. And that actually came to a head under President Biden, because he had basically reinstigated an effort that had been underway under President Obama to essentially have the EPA order the industry to move to renewables, even though Congress had not passed a law requiring that. And they did so on the basis of, this kind of reading into the gaps in federal law, on understanding that that's a permissible interpretation of the law and therefore a permissible policy to pursue. And that's really difficult and problematic for industry, as you can hopefully see. I mean, if you're getting whipsawed, imagine, you run a power generation plant, you're trying to do it right, you're trying to keep it clean, but you're also trying to deliver power at a reasonable cost for your consumers. And every time you get a new president, you're getting whipsawed back and forth about whether you should be using windmills, or coal. That's not great. And so hopefully the advent of this new framework for interpreting statutes that empower federal agencies will at least bring more consistency. I think that would be good, even if you don't necessarily like the policies that emerge, and you'll probably like some and you probably won't like others. But if we get more consistency where regulated entities like drug companies, power companies, and others are not constantly getting whipsawed back and forth on policy, I think that in and of itself will be a good development. I think I'll stop there because I said I was more interested in your questions. I am. But again, I really appreciate the hospitality. I hope you found it interesting. If you didn't, no problem. We can call an audible and you can ask me about whatever else you're interested in. But does anybody have a Loper-Bright Chevron related question? We could start with that. Yeah, hey.
In the context of regulation and your work in these different types of laws, what's your opinion on prophylactic rules, like Miranda rights and the exclusionary principle?
I love the question, but I didn't hear the last 5 words. What was the last bit?
Like prophylactic rules, like Miranda rights and the exclusionary principle?
Oh, interesting. Miranda rights and the exclusionary rule. Wow. So for those who don't know, so a prophylactic rule is one that essentially tries to address harms before they happen, right? And then the 2 examples that were given were features of American criminal procedure that I think are fairly described as sort of judge-made, in the sense that they cannot be derived from the express text of the Constitution. The first is one I assume most of you are familiar with. It comes from a decision called Miranda v. Escobedo, where the Supreme Court held that you have a constitutional right to be advised of your right to remain silent, which the Fifth Amendment guarantees, during any custodial interrogation. So if you're just having, an exchange with a police officer on the street and they start asking you some incriminating questions, they don't have to Mirandize you because you are not in custody. But if they take you into custody and want to ask you questions, or at least if they want the answers to be admissible in court, they have to read you those rights. That's Miranda. And then the exclusionary rule, again, probably most of you are familiar with this, is essentially a remedial doctrine that the Supreme Court have essentially devised to effectuate the Fourth Amendment prohibition against unreasonable searches and seizures, so that if the police discover some piece of evidence by violating your Fourth Amendment rights against unreasonable searches, then that evidence generally will not be admissible in court unless some exception applies, which, aside, it almost always will. Things like good faith, or we made an honest mistake on the warrant. That's another good faith exception. So I think it's a really fascinating and astute question, because as a professional kind of and also frankly personal libertarian, I feel very strongly that the government is every bit as prone to making mistakes as the rest of us, if not more so, and those mistakes can have a pretty awful effect on people's lives. So I think that having prophylactic rules that try to prevent those mistakes from happening before they do is a generally enlightened policy, but the devil's in the details. The devil's in the details. And I'll just maybe do a quick riff on some of the most interesting scholarship on the exclusionary rule has been academics on the left. I'm talking about progressives who have called for the elimination of the exclusionary rule. And if you think about that for a moment, that seems weird because generally speaking, progressives tend to be sort of more supportive of the rights of the accused and more suspicious of the criminal justice system as I am. So why on earth would they be arguing for the elimination of this defendant favoring rule that just results in the exclusion of incriminating evidence simply because of the way that it was obtained? Do you have any, tell me your name. Allison, do you have any thoughts about why people on the left might want to get rid of the exclusionary rule?
I think, well, like when we look at the permissibility of certain evidence, it's like with, I don't know, kind of that political posturing when it comes into like using certain types of things. They might find that favorable.
Good. It also has a really practical effect. You know what practical effect the exclusionary rule has? It makes police lie. And believe it or not, there was a fascinating, you would think that would be difficult to determine empirically, and it is, but there was a fascinating study that was done that showed that before the exclusionary rule was announced, if police got into a foot pursuit of somebody they suspected of carrying drugs, that person almost never threw away the drugs. So if you caught them, they were still going to have the drugs on them. Then the exclusionary rule gets announced, and suddenly everybody who's fleeing police throws the drugs away, right? Does that sound plausible to you? That you know, like drug dealers down at the street level would just massively change their behavior because of the exclusionary rule, which most of them never heard of? No. What's happening is cops are still catching them with the drugs. They're just saying, oh yeah, he threw the drugs when I was chasing him, so there's no Fourth Amendment issue. Because your Fourth Amendment, once you relinquish personal control over an item like drugs, you don't have any Fourth Amendment interest. So the Fourth Amendment problem goes away if the suspect throws the drugs, right? So whether they did or they didn't, the police were like, oh yeah, he totally threw the drugs when I was chasing him. Do you see what I'm saying? So what the scholars argue is that the exclusionary rule has had a net detrimental effect on the rights of the accused by sort of going back to public choice economics, causing police to behave in a way that on balance is worse than, admitting potentially tainted evidence. And I'm not sure how they come down on that, but I think that's pretty fascinating. There are other arguments that are made as well. You know, another one is just a basic argument of justice. You catch somebody who is absolutely a murderer, right? And, you didn't read them their rights at the right point along the process, or you didn't have a warrant when you went into their house and looked at the closet where you found, whatever, the shovel and the rope and the bag of lime, and that person doesn't get punished for that murder because of that. That's pretty tough to stomach. It's one of the reasons, by the way, why most countries don't actually follow the exclusionary rule. In fact, in England and Canada, they do more of a rule of reason, and it's in the sense that they sort of look at, well, how egregious was the violation in comparison to the probative value of the evidence that was collected. Does that make sense? So I'm torn. I generally like prophylactic rules, but as we were talking about at dinner, you oftentimes get unintended consequences, and those can be a real bitch, if you'll excuse my French. And there's often no way to really know how it's going to work out in practice. So I think a large dollop of humility when you go about making prophylactic rules, and humility about your ability to predict how they might actually play out in real life is always warranted. Does that make sense? That's a great question. Good. Thanks for starting us off. Felt like somebody over here was like starting to raise a. Okay, there we go.
I think with the Chevron doctrine, we typically think of it as something that's to the detriment of private companies, like in the local right cases, this can happen. But there's also sort of the flip side of that, where you have this litigation to force agencies to more stringently enforce rules, like a lot of the big environmental ones, like the Endangered Species Act.
Yeah.
So I'm wondering if you think there's a chance there will also be, especially in case we have, like currently, the government agencies trying to do less with those major laws, that will lead to more red tape or more regulatory uncertainty for private companies.
That's a fascinating question. Tell me your name. Aiden. So I want to reformulate it, just make sure everybody heard it. If I get it wrong, tell me. But so your natural inclination might be to think that if the government or if the judiciary no longer has to defer to an agency's interpretation of a given statute, that this is going to be kind of a free pass for a lot of industries, right? And there'll be, more room to operate, more opportunity to, pollute streams and so forth. But in some settings, and I think you mentioned the Endangered Species Act, you could actually see agencies being required to be more vigorous in their enforcement of those laws. Maybe under, some administration, they might think, well, I don't really care about the great horned owl or, whatever, the spotted snail darter, and we're just not going to enforce those laws, protecting their ecosystems, right? And then somebody files a lawsuit and says, well, actually, the law does require you to, let's say, forbid construction within a mile of some, river system where that amphibian lives. So do it. Right? Is that the essence of the question? Yeah. No, I think that's a really fascinating question. I think the answer is almost certainly it'll go both directions. If the question is what is the net result likely to be, my sense is that probably the former. Probably on net, less agency discretion will probably redound to the benefit of what we might think of as regulated industries like the pharmaceutical industry, power generation, et cetera, for a number of reasons, including because they tend to be more likely to be subject, if you look at the proportion of regulations that apply to different, areas of human endeavor, I would say a disproportionately high number apply to things that companies are doing, whether it's extracting, resources from the ground or just operating a business, right? If you operate a business, you're subject to OSHA, the Occupational Safety and Health Administration, and then proportionally the kinds of laws that apply to things like protecting endangered species. And you gave another example. What was the other example you gave? Do you remember?
Or even, like a lot of those regulations, like it's not get sued for not OSHA regulations.
Not traditionally a problem at OSHA. They actually have a regulation, I think, that requires you to label water. If you have big vats of water on your business, that actually has to get labeled as like a potentially hazardous chemical, which as a lifeguard, I do get it, but it's like you have to really try to make water hazardous. But anyway, so on net, my sense is that it's going to cut in a pretty pronounced way towards a relatively constrained new environment for regulatory agencies and more room to work for regulated industry. But there will probably be some times when it'll go the other way. And there is this kind of interesting, have you ever heard of a sue and settle approach? It's a tactic that sometimes public interest organizations will use where they'll sue an agency to implement or enforce a policy that the agency itself might want to actually enforce, but they haven't been able to complete the required administrative procedure, something called notice and comment, which you have to go through to implement a new regulation. And so the agency will kind of go into court and take a dive like in a boxing match where they just don't even try to defend themselves. And then lo and behold, the public interest plaintiffs who are trying to get some policy enforced, protecting some new species or something will win. Or sometimes they'll settle and the agency will just agree, oh, okay, I guess we'll settle and yeah, we'll agree to protect the snail darter from now on. And then they are now legally obliged to do that. And that's a kind of a way of getting around the Administrative Procedures Act that might have prevented them from actually implementing that as a regulation. Well, guess what? Now that it's a court order, they have to do it and they're not all that unhappy about it. This is a great question. Again, I think there'll be some of both, but I'd be surprised if it didn't sort of markedly favor what we think of as regulated industries. Yeah. Yeah. Hey.
I know you said it's seemingly probably impossible to predict what the outcome of this decision will be, but trying to position it within the current administration. It seems like Trump is pretty poised to make or try to make some considerable ground in administrative law.
You think?
So I guess maybe not necessarily in an absolute sense, but aggregating it to the way that this decision will kind of hinder his efforts and maybe also help.
Oh man, I'm struggling so hard not to be snarky right now. I think you need something other than an assembly of spider monkeys and howler monkeys in order to actually take advantage of this situation. It's not clear to me that they have access to that. I'm kind of not joking. There's been such an out-migration of talent from the Department of Justice, and the people they put in charge of administrative agencies, I do not think are necessarily among your more strategic thinkers. So is it possible they could take advantage of this? Yeah. Are they likely to be able? Just look at how they've screwed up immigration, right? For however you feel about it, everybody who's in this country unlawfully is subject to being deported. There's no legal dispute about that. You just have to dot a couple of I's and cross a couple of T's, and they've messed that up, right? And they really have. They have unnecessarily picked a fight with the U.S. Supreme Court over their decision to send, let's just say he's not here legally, an illegal immigrant, to, a gulag in El Salvador. And because they just couldn't be bothered to give this guy a 6.5 minute hearing, that's all they had to do. Nope, didn't do it, right? So yeah, the opportunity is there, and no, they don't seem to be able to take advantage of it. So I don't think that, I'm not saying it will be irrelevant, but I don't think that's how they're going about it. And maybe we'll see a change. If, for example, there's a significant reallocation of power, like if the Democrats take back the House in the midterms, then I wouldn't imagine you're going to see like a sudden onslaught of like new legislation. But maybe something will change where the administration will change its tactics and sort of realize that there's a bigger opportunity here than it appears they realize. But right now, as best I can tell, they're just they're just going for broke on everything they want to do through executive power. And they don't particularly care whether there's a statute or not a statute. I mean, this is a president who basically presumed to have eliminated birthright citizenship that's guaranteed in the 14th Amendment through executive order. That's not like high-level tactical thinking. That's wish casting. And I think that's going to get shot down. Whether it goes down slow or fast remains to be seen. So I guess I'll take one foot off the soapbox now and go back to just being the guest speaker. I wouldn't look to this administration for a lot of really subtle use of soft power, which is what I think we're talking about. Tell me your name. That's a good question. Thank you for that question. Anybody else? Yeah, hey.
Yeah, you've mentioned a few examples like the renewable energy and integration about the specific, applications of the lack of Chevron defense. What do you think about net neutrality and FCC? Because that's also one that seems to be somewhat polarized in terms of which administration's in the office.
Yeah. I don't know a lot about this. I'm very up to speed with what happened with TikTok and to some extent the job owning at Facebook. But tell me what exactly you mean when you're talking about net neutrality.
I was thinking about Biden's proposal in the previous administration to sort of provide broadband networks to everyone and not allow companies to hike it based on geography or social status, whatever.
Yeah, so basically sort of providing widespread access to the internet and without a lot of price differentiation, right? I mean, look, I think that's somewhat similar, and somebody please jump in if I go off. I mean, I fessed up right away. I don't know a lot about this, but my sense is that this is another one of these issues about which reasonable people really can disagree. And there are trade-offs in terms of embracing net neutrality brings with it certain benefits, but also certain costs, and then rejecting it, same thing, some benefits, some costs. And as with so many things, this has been very much on Congress's radar screen for years, and they haven't really done anything in this area. They have not embraced some definitive policy. So then the question becomes, is this up for grabs every time you get a new administration? And as you probably sort of picked up on by now, I think that is generally not ideal. I think it is better for a couple of reasons to require that Congress be the primary, or if we're going to follow the Constitution to the letter, exclusive implementer of policy, because it's more democratic, first. Congress is also equipped with the ability to undertake long-term studies, for example, that may ultimately lead to better policy outcomes. I'm not saying that it always does, but at least in theory it could. And when you allow agencies to do this, and when I say this, I mean essentially be responsible for making big decisions like whether we should have net neutrality, or whether, to take another Supreme Court case, like bump stocks should be illegal. And if you don't know what that is, it's a device that enables you to take a semi-automatic assault weapon and make it effectively go full auto. And it was the device that was used to murder a lot of people in the mass shooting in Las Vegas some years ago. Congress, so that there was a agency ban on bump stocks. The Supreme Court struck that down, not because it was a bad idea, but just because the agency wasn't empowered to do it. I think it makes a lot of sense to force Congress to take responsibility for implementing policy. And what Congress tends to do now is sit back and say nothing on controversial issues and essentially exert pressure on the executive branch to have the agencies implement the policy. So that if it turns out good, Congress can take credit for it, right? And if it turns out bad, they can say, oh, well, that's the agency, that's the FCC. We didn't tell them they could do net neutrality, right? And I think there's a lot of moral hazard there for reasons I presumably don't have to spell out. So Congress, I think, is really atrophied lately. And that's an open-ended term. I'm not really a historian, so I wouldn't say when it really began to be so pronounced. But I mean, Congress has quickly become the most irrelevant branch of government, frankly, because it refuses or has sort of lost the understanding of how to exercise the kind of power that comes with the push and pull of the legislative process. Compromise, log rolling, all of those sort of internal dynamics that at one time members of Congress seem to have been more adept at than they are now, whereas all they want to do now is go on TV and run for president and throw rocks at policies they don't like. So I prefer to see policy made in the legislative branch, not only because that's what the Constitution says, but because I think that's generally healthier from a sort of democratic accountability standpoint. As for net neutrality, I don't have strong feelings on that one way or the other than to say whoever implements that policy ought to do so democratically and take accountability for whether it works out or not. Does that make sense?
Let me jump in on that, because we are going to talk about net neutrality tomorrow night.
Oh, thank God.
But the issue there, for those of you, it was a big deal when I started teaching here, because John Oliver did a segment on it, had millions of views, and everybody signed a petition to go to the FCC.
Yeah.
But the issue has to do with who pays for use of the internet.
Yeah.
And it goes back almost at least a decade long, or 15 years now, to when Comcast was throttling BitTorrent. BitTorrent was a huge part of internet traffic. And Comcast started throttling them and charging them, and they sued. And this rule was passed called the Open Internet Rule, but then Verizon sued the FCC and got it overturned. And the issue, people have made it appear like it's a grassroots issue. The truth is, it's not a grassroots issue. Who wants the internet usage to be free?
Google.
People creating content. Netflix, John Oliver's HBO. Essentially, John Oliver's segment for HBO was a big infomercial for the content creators at the time. Google, Netflix, HBO, whomever. And so that became a big rallying cry on this issue. People that hated it, Verizon and AT&T, people who actually built the thing, and the pipes that it flows upon. The issue goes to, can you have price discrimination?
Yep.
Is this thing such a public good and such a public utility that price discrimination is somehow discriminatory or unlawful or unfair?
Yeah.
But look at the issue. What's fascinating about net neutrality and what we're right is there is a parallel. Is they began with somebody upset that the state wasn't going far enough, because in the original, the Chevron deference came from the fact that the NRDC sued the EPA, saying the EPA wasn't regulating Chevron most stringently enough. And the same thing is true of the FCC in this particular case. But the problem is, as you're pointing out, is it just becomes a great big political football. A new administration comes in, and they either reinstate everything that the previous administration deleted, or they delete everything the previous administration did. This was the first Trump administration deleted everything the Obama administration did. That was Ajit Pai. It was this big issue. He ran on. He became head of SEC, and the first thing he did was delete all of it.
Yeah. Trivia question. Does anybody know who was in charge of the EPA during Chevron?
They know this.
Oh, do they?
His mother.
Yeah, it was Neil Gorsuch's mother. Isn't that funny? Runs in the family. But yeah, so great question. I'm glad. Thanks for the additional background. Yeah, hey.
Our administrative state is rather unique, with litigation being at the heart of it. What other countries are radically different? What can we learn from other countries in terms of improving the administrative state?
That's a great question. I actually don't know. I'm not a comparative legal scholar, and so my knowledge of other countries mostly comes from going and visiting them. It certainly appears to be the case that many other countries just have a better handle on how to operate bureaucracies than we do. And I mean that like not in a sort of I'm not throwing shade at them. They just make the trains run better, and people seem to have more, more confidence in the competence of what we call bureaucrats. I hate to sort of cop out, but my sense is that just there's sort of a higher level of professionalism in countries that whose bureaucracies operate well. It's sort of, it becomes sort of your occupation to make the thing that you signed up to do work well. And I think in our country, it seems to be more of a political football. And so you get that push and pull, you get the whipsawing. Look, we have some experience with highly effective administrative agencies, and my dad worked for one. My dad was a NASA engineer, and he helped put a man on the moon. And NASA worked really well for a period of time. And then I remember him telling me why he walked out the door, because I'll spare you the details, but he had an experience that made it very clear to him that NASA had just gone back to being a regular bureaucracy. So I don't know if it's a sense of mission or professionalism or what it is. It may be that there are different legal structures in those countries that have had to make them more reliant on well-functioning, bureaucracies. And, maybe it's our allocation of powers among more governments and doing more things, or up until, somewhat recently, more things at the local level. But I just, my sense is that we're behind the performance curve and in getting administrative agencies to deliver in the way that other countries do. But I'm afraid I really don't have a prescription for I have neither a diagnosis nor a prescription, but I appreciate the question. Yeah, hey.
Yeah, you mentioned that criticisms vis-a-vis the local right decision abound. You mentioned that an unfair one was the courts will disregard agency expertise criticism. I'm curious if you could speak to any other ones, and if you think that any of them have any force, or if they're
Oh, I'm trying to recall what some of the more, prominent one. That's the most prominent one that I can think of. Feel free to jump in if any come to your mind. But I do think, there's sort of a judicial bandwidth issue. That the courts kind of have there are only so many hours in the day, and courts have to spend a certain amount of their time, resolving disputes between private litigants. Not for nothing, we also incarcerate more people than any other country in the world, I think, except for El Salvador now. Higher percentage. But our courts have a lot of things that they have to be responsible for, and this kind of litigation can get very complicated and very time-consuming. So I think there was almost certainly a kind of a cost savings and a streamlining effect of saying, it's sort of like a heuristic, like, well, listen, probably this agency got it right, and we don't have to devote as much judicial bandwidth if we start with that presumption. Does that make sense?
Yeah.
Anything?
Well, I was going to ask you is if you think that it's going to simply push more power into the judiciary away from the executive.
I guess, but I don't think. I know a lot of judges, and they're not like hankering for more cases to get filed. They're just not. They're harder working than you might realize, and so like, who doesn't want more power? I suppose you could say that. On the other hand, I think the judiciary already has a pretty full plate. Congress has been extremely stingy about authorizing new judgeships. They haven't done it in a long time, and so the number of judges deciding cases has remained relatively fixed, even as the number of cases that they have to decide has exploded. Somewhat similar to I think the number of taxi medallions in New York City has remained relatively fixed as the population has exploded. So, it's certainly possible that there will be a power shift, and I suppose, descriptively speaking, that's undeniable. But my experience is that judiciary is actually the least power-hungry branch by a considerable margin. I understand that some people dispute that, fair enough, but having sort of litigated in that system for most of my career, my experience is that judges are generally sort of like parents, with two kids fighting in the back seat. Anything that they just stop fighting and let me go inside and have a drink. Maybe.
One thing we debate in class, and I think this is a thought experiment, is whether there's almost a libertarian argument for an administrative state, in the sense that Congress they're not experts, they're so removed.
Yeah.
And you can have experts who are close to an issue. And as long as there is a process that follows APA, that you arrive at something that is an outcome that is arguably more just,
Yeah.
and more efficient,
Yeah.
than if you said, Congress, you have to be specific about everything.
It's a great point. Maybe this goes back to the exchange we had just a moment ago here, that if the government is good, like, I personally don't think that the federal government should be involved in education. That's me. I don't see it in the Constitution. There's no delegated power that I can find, and I'm not a big fan of what they have done. But if they're going to do it, if the federal government is going to be involved, I'd rather they be involved in a way that is professional and efficacious. And a well-functioning administrative state is presumably going to have a greater likelihood of executing its functions. Kind of reminds me of, I don't know, you're probably familiar with Phil Gramm. I guess most people are. Phil Gramm was a pretty prominent senator from my home state of Texas who was also an economist. And he had this funny saying, it's not 100% relevant, but I did just tell one of my kids about it, so I'll relate it, that he he absolutely would not agree to help fund a mission to the moon to mine for green cheese, because the moon is not made out of green cheese. But if that mission is going anyway, he's going to make damn sure that rocket's built in his district. And so what I'm getting at here is to say that you can be opposed to something like I am opposed to federal involvement in primary education, but if it's going to happen, you can still want it to happen in a way that works. So two things, I think both of those things can be true. And yeah, so I think that whatever the federal government's going to be involved in, I'd like them to do it well. And that I don't think they're meeting that standard across the board.
One more
All right.
question.
All right.
Thoughts on the compensation difference between big law partners and the federal justices who are hearing their cases?
All right. Well, I happen to know a lot about compensation in big law, not because I was ever one of a partner there, but because I was one of the lawyers in the Heller gun case. And it turns out when you win a case against the government, even if you were pro bono, which we were, you actually get, you're entitled to a fee award. So we had a big, long argument about how much our services were worth. I don't know how many people are familiar with that procedural history of that case, but as it became more and more clear that we might actually win, the District of Columbia, who was the defendant, kept bringing in more and more big law firms. So we were up against, at one point, like 25 partners at 3 of the biggest law firms in the country. And so when it came time to make a fee request, we were like, well, let's take a look at how much they were charging, because you have to calculate, an hourly rate. And it's, it's a lot. Like, tax partners, I think, are among the most highly compensated because basically they come up with ways to save you like $1 billion in taxes, which is really worth something. They'll charge a couple thousand an hour. There's a guy named Paul Clement who's probably still the #1 Supreme Court litigator. He's the guy you bring in a bet your business litigation in front of the Supreme Court. I don't know what his rate is. It's reputed to be $1,300, $1,400. He might be up to $2,000 now. So you've got big law partners that are billing well north of $1,000 an hour. And these cases end up in front of a Supreme Court consisting of, mostly career judges who have made it to the pinnacle of their profession, where they make, I don't know what a Supreme Court justice makes, but it's not more than $300. I think it's $250 or something like that. I don't know. Maybe you should tell me what you think. I mean, obviously you wouldn't ask the question if you didn't see some, tension there. On the other hand, I will say this. I'm not an economist, but I sometimes play one on TV. I have lots of friends who are. Compensation comes in more forms than just money. And having a job where people stand up as soon as you walk in the room and shut up the minute you start asking a question, that's worth something. To be one of the 9 people who decides momentous questions like reproductive freedom or who gets to have a gun, there are some people for whom that provides a great deal of hedonic benefit. And I would be hard-pressed to assign a dollar value to it, but there is no shortage of people clamoring to be pulled into what you might think is the entry level of that pipeline. I'm talking about a federal district court judge, which is not, usually you go from being an appellate court judge to the Supreme Court. But I'm talking about people who would crawl over broken glass to kill somebody else's mother to get an interview to be a federal judge. And that's barely an exaggeration. So whatever, the monetary compensation might look like on paper, I can assure you that the full package of compensation, including the non-financial, is pretty enticing to at least some people. My heart does not go out for them. And maybe that's just because I've been a public interest lawyer for my whole life, earning considerably less than big law partners and not bitching about it. And no one stands up when I walk in a room. All right, on that note, you guys have been really great. Thanks so much.